Would you raise your right hand, please? Do you solemnly swear or affirm that the testimony you give will be the truth, the whole truth, and nothing but the truth, so help you God?
Ma'am, do me a favor. Go ahead and spell your first and last name for our court reporter.
Ramona Rumpf, R-A-M-O-N-A-R-U-M-P-H.
And Ms. Rumpf, where do you work and how long have you been doing that?
Seminole County Sheriff's Office since May 19th, 1987, and I'm the Deputy Director of the Communications Division, which encompasses the custodian of records.
Okay. And the Communications Division, is that what we've heard from Mr. Nofke, is the 911 and non-emergency call center?
Yes, it is.
And when you say you're the records custodian, that sounds like a big job. What is it?
That's maintaining the calls that are received on 911 and non-emergency lines, and also the CAD screens, which is the computer-aided dispatch for documented events.
And how long have you worked there for the Sheriff's Office?
For 26 years.
And Ms. Rumpf, the nature of your duties, does that involve occasionally having to retrieve and verify records of prior calls?
Yes.
And are these calls documented both on tape as well as in written memoranda that are prepared for records purposes?
Yes.
Mayor, if I could approach. Ms. Rumpf, I'm showing you what is first marked as State's Exhibit 171 and 172, a composite exhibit, and then three more, 158, 159, 160, 161, and 162, 163. Do me a favor. Tell me if you have seen these exhibits and if you recognize them as true and accurate records maintained by your agency and retrieved by yourself.
Yes, I do.
Your Honor, to the extent they haven't been received in evidence yet, I would move those numbered exhibits as into evidence.
Numbers 159 through 163 have been. Numbers 171 and 172 have not. Are there any objections?
No, Your Honor. In sequence, the first ones are the 911 calls, no objections, and then 171 and 172. Thank you. No objections.
No objections. 171 will come into evidence, and so will 172.
Let me first start, Ms. Rumpf, with the distinction between 911 and non-emergency calls. Tell us a little bit about that and what the difference is into how those two calls are treated by the call center.
A 911 call is a call placed at the time of an emergency or the time that the person's deemed that they have an emergency. All of our calls are recorded when the line rings, and a CAD screen is created for dispatch. And a non-emergency call is just that, received on an administrative line, and it is received with crimes that are over with or a crime that is non-life-threatening.
Were you asked to retrieve a series of prior non-emergency calls placed from a particular phone number by George Zimmerman to the call center beginning in August of 2011, extending through the early part of February 2012?
Yes.
And are those represented in, I believe it's 171 and 172 before you?
Yes.
Okay. Are there written documents affiliated with each of those?
Yes.
Okay. And they are also on a disc recording?
Yes.
Okay. If I could, I want to talk a little bit about these written reports that are made. You're familiar with those and the information those contain?
Yes.
All right. I'm going to, would you be able to help explain what one of those looks like to the jury and what information is contained on one of those?
Yes.
Okay.
It is, as I stated, a what we refer to as a CAD screen, which is computer-aided dispatch. And that screen is created whenever you call in a complaint, and it is the date and time that is it's time-stamped, so to speak, like you would have on a receipt when a call is received, and we complete the information that the caller is giving us, the location of the event, the type of event, the person's name and phone number, if they're willing to give it, and any additional information regarding that event is obtained at the time of that call.
And Your Honor, could I request the lights, please? Yes, sir. Thank you. Ms. Rumpf, directing your attention to the screen up here, and I know that may be a ways to try and see it. Let me ask you in general terms. Up here in the top left corner, is this, for starters, is that what you recognize to be one of the written records that you've just been describing?
Yes, it is.
And up here in the top left corner, there's a phrase called an event number. Would you tell us what that means, please?
An event number is basically like what it sounds. It is associated with an event, and it is created by the system. So it is linked to an event. It's basically what it sounds like, an event number, like a case number, so to speak.
And tell me about the times that are available to the people who keep the records in the call center as far as telling when a particular call connects and disconnects and how that is recorded.
The information is the Annie and Allie information up in the upper left-hand corner, and it gives you the date and time. Annie and Allie is automatic number identifier and automatic location identifier, ANI and ALI. And then it has a minute and second. The next time is the connection time, which is also date and time stamped. And the next time is the created time, which is also date and time stamped.
What's the difference between those two, connected and created?
The connection time is the time that we actually picked up the phone and answered the phone. And then the created time is the time that the person taking that phone call sent that call in, or event added it, sent it in to be dispatched, sent in a call for service.
Down in this section of the report, you start with location and caller name and that sort of thing. Where does that information come from?
That information on this call would have been given to us by the caller, Twin Trees Lane. The
And
caller. I'm sorry, go ahead.
And this particular call, is this a 911 call or a non-emergency call?
That is a 911 call, and you can tell from the call source.
That tells you that right there where I just drew a very bad circle?
Yes, where you drew the very best.
Okay. And is there a priority affiliated with this call?
Yes, it is.
And what is it?
3.
What does that mean?
That is a routine call.
I'm sorry, priority 3 means?
Routine 1, 2, and 3.
Okay. Tell me, how would a 911 emergency call be a routine prioritization, and does prioritization ever change?
Yes, it does.
Okay, tell me how.
Based on the information, like I said, a 911 call can be placed at the time a person deems that they have an emergency. During the course of that call, as information is obtained, that call can be changed or upgraded. So it can start out as a call that's routine. However, the call taker can make that decision to upgrade that call based on the information that is being given to them or the information that they are obtaining from the caller.
And is that what happened with this call?
Yes, sir.
Does that tell us that down here?
Yes, sir.
Okay. Where it says the big word upgrade?
Yes.
Okay. As far as the information that you could glean from this, is there a way to tell whether this call might be related to any other calls or any other incidents?
Yes, it is.
How can you tell that?
If you will look up the screen, so to speak, you will see where it says C event 1671, and that is our way of tying events together. So it's saying that that event was EVD, which stands for a duplication, and we used one primary screen at that time, which was event 1671.
Now, Ms. Rumpf, there were a number of 911 calls placed that night.
Yes.
And were they all essentially, did you determine whether they were related or not?
Yes, I did.
Okay. Specifically, the date that was reflected on that one, and I guess on all the 911 calls, that's the 26th of February 2012?
That's correct.
Okay. I'm going to leave those aside for the moment. I want to go to the non-emergency calls, the prior calls by George Zimmerman to the call center. You're aware of those?
Yes, sir.
Okay. And did, tell me the date on the first one of those that you have in front of you. And Your Honor, we can, thank you.
Thank you. August 3rd, 2011.
That was August 3rd, 2011?
Yes.
And that was placed from which phone number?
407-435-2400.
Can you tell me the priority affiliated with that call?
It was a routine call received on an administrative line, non-emergency line.
And have you reviewed the recording that's in front of you already in evidence?
Yes.
Your Honor, with permission, I'll publish that recording.
You may do so.
Thank you.
Burglarized or robbed today, and my wife's always.
Airport Police Department, the line is recorded. Teacher.
Hey, our neighborhood got burglarized or robbed today, and my wife, I saw one of the kids that did it, and we see someone that matches his description in the neighborhood right now again.
Okay, and what's your address out there?
I'd rather not give out my address because he's obviously in the neighborhood, but it's Retreat View Circle. You can use 1111, which is the clubhouse.
Okay, so does he live in the neighborhood, or he's just out walking?
I don't know. It's the first time I've ever seen him.
Okay. And what is your name?
My name is George.
And your last name, George?
Zimmerman.
And your phone
Like
number
I
you're
said,
calling from?
407-435-2400.
Okay. And is he white, black, or Hispanic?
Black.
And what's
My
he
wife
wearing?
talked to Detective Walker and gave him a description of the guy we see now.
Okay. And what's he wearing right now?
A white tank top and black shorts, and brown sandals and black socks.
Okay. And is he walking?
Yes.
Okay. And so is he near the...
The back entrance to the neighborhood.
So he's at the back entrance?
Yeah.
He just went between the houses.
He just went between the houses to the back?
Yeah.
Shoot.
He was looking at the car.
I'm not.
No, he's not.
Why not?
No, don't call. Okay, we'll get an officer out there, check the area.
Okay, thanks.
You're welcome.
Mr. Rumpf, what time of day was that call placed?
At 18:45.
I'm sorry, is that 6:45 p.m.?
Yes.
I'm going to move to the next call, which
Your
would...
Honor, I then would move to strike the testimony and the exhibit unless there's a relevancy to this. I presume it would come,
I asked if there was any objection to the exhibit being introduced, and you said no.
but not to relevance of it. And I hope I didn't misspeak, but I would have presumed that there would have been some...
There was nothing spoken. I asked exhibits, I had announced that exhibits 158 through 163 were already in evidence, and asked you if you had an objection to 171 and 172, and you said no.
You are correct, Your Honor. I would ask you, and I apologize, I thought we were talking mechanics rather than admissibility or relevance. I would ask, I still would move to strike the testimony and the underlying exhibit on grounds of no relevance. And I apologize if my statement suggested that I found all of these to be relevant. I thought we were dealing with mechanics.
When I ask if something's being admitted into evidence, and the answer is no, and I said they will come into evidence as 171 and 172.
You're correct, Your Honor.
They're in evidence and they're allowed to publish them. So now you want to object to the two exhibits?
Yes, Your Honor.
Ladies and gentlemen, if you'll please put your notepads face down, there's something we have to take up outside your presence, and follow Deputy Jarvis back into the jury room. Please be seated.
And I truly apologize for the confusion. The objection is that it is not relevant to any material issue in this case. He's being charged with second-degree murder. I don't find any,
Okay,
well,
your
that's all I
objections-
need to say is relevant. Sorry.
Relevance response?
Certainly. Your Honor, we have heard already extensive testimony about prior comments during the evidence that did not get objected to, that being the non-emergency call from the date in question, February 26th. Included in those comments was, these assholes always get away. And I think it is certainly relevant then to meet some of the calls about which the defendant is speaking when he says they always get away. These calls are relevant to establish what it is and the context behind that statement. Number two, Mr. West went to great lengths in his opening statement, and there has also been additional discussion already about the evidence already, the exhibits already in evidence about supposed prior break-ins and prior crimes and that sort of thing in the neighborhood. Again, this shows this defendant's response to what he's complaining about when he calls even on the date in question. It's a 6-month period immediately up to and preceding, and in fact one of them preceding by about 2 weeks, the incident in this case. So I think it is relevant to show the defendant's state of mind when he makes the call on the 26th to explain what it is he's talking about. And there's certainly no objection as to their authenticity. So that would be, I think they're relevant to prove material facts that have already been admitted and argued about at length.
Response?
Well, the response is, again, the state needs to show that they are relevant to a material issue now. If what they're saying is that these are prior, bad acts of my client, there is a specific provision.
I don't think it's under bad acts.
Okay, so it's not under bad acts.
State of mind.
State of mind. A exception because he's thinking a certain way. I think that they would have to meet a much higher burden than to say that because he said fucking assholes and fucking punks.
No, I think it's what they're saying is because he said they always get away, and
And that there have been a lot of break-ins.
there have been a lot of break-ins, and
Okay.
that was brought out in openings.
Absolutely, but why does that make prior events, or prior calls for that matter, relevant to today's proceedings? He said they always get away. If, for example, he said they always get away in some aggressive manner, which was not testified to, the only witnesses testified to this evidence, there may be some connectivity, but without that, what they're really trying to do now, I guess, and I definitely would want to proffer, because if you're going to go back and say he's done something 5 or 6 times, it has to be relevant for this court's consideration. Other than that, they're trying to show some, they may not be calling it bad acts, but why are they presenting it if it's not? So what's the relevance? Isn't the real reality that the state carries the burden of proving that my client acted with ill will, hatred, spite towards this Mr. Trayvon Martin at all? So how does, not that they're, how does anything in the past get brought in if it's not reputation, which it's not, if it's not a prior bad act under some other exception, it's not. So how are they bringing in something 5, 6, 7, 8, 10 months before as having a relevancy to today's proceedings?
I'll spell it out even further if I need to, Your Honor. The relevance is that this defendant, if we have to establish his state of mind, which is an element of second-degree murder, last time I checked, malice, ill will, spite, and evil intent were all directly related to the state of mind of the accused perpetrator. And also, jury will be instructed that this is an act or series of acts I think it is certainly relevant to show the defendant's state of mind on this night, whether it relates to this particular victim or not, is brought about by his constant and ongoing frustration over, quote, these assholes always getting away. So it is relevant. It's relevant to show the basis for his comment, as well as what's been going on. And oh, by the way, it's already been, again, admitted and talked about as far as the defense claiming that there were all these prior break-ins. So let's talk about them then.
A brief response. I think what the state is now focusing on, I want to make sure before I fully respond, that they're trying to get this in under a state of mind, a then existing mental, emotional, physical condition. I think a review of that subsection of the evidence code dealing with the hearsay statement suggests that if they are trying to prove the then, if that's where they're going, they're trying to prove the then existing state of mind, my client's state of mind when making the 911 phone, the non-emergency phone call on the 26th. What they're really trying to do is say, well, let's go back and see that, for an example, you may find out in this call that he was calling about a black male. So if that's what they're going to do, they're going to try and say to this jury that he called them a black male before when there's no connectivity between the two. That's a bad act that you're trying to get in, and that's not state of mind. And if you read the state of mind provision, it's quite limited in proving my client's state of mind on this day. And how do you do that? You listen to the tape. The jury can listen to this tape and decide what his state of mind was.
Actually, Judge, the exception that the state provided for these calls is that they're business records. State of mind is a hearsay exception. They might otherwise qualify, but state of mind is an element of the crime of second-degree murder. They've been arguing that since the get-go and actually read the jury the instruction during voir dire. So the state's doesn't have to meet the state of mind hearsay exception requirement to enter this into evidence. The business records exception does that. It's admissible for that purpose. State of mind is an element of the crime, and therefore this is relevant to establish the defendant's state of mind when he says, these assholes always get away and there have been a lot of break-ins.
Okay. Does anybody have any case law to support their argument?
Well, not anticipating the argument, I don't, Your Honor, but if we wish to recess for tomorrow, I'd be happy to try and go get some. I don't have any to hand you right now because I didn't know where, I thought they were coming in. I didn't know that there was going to be an objection.
Well, there wasn't an objection at first, and now there is an objection, so that's the status of where we are. 90.803 subsection 3 is the then existing mental, emotional, or physical condition. A statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, motive, design, mental feeling, pain, or bodily health, when such evidence is offered to prove the declarant's state of mind, emotion, or physical sensation at that time or any other time when such state is an issue in the action. Prove or explain acts of subsequent conduct of the declarant.
Certainly the events of February 26th being subsequent to August 3rd.
Okay. Well, I will...
I'm sorry, just...
I will go ahead and recess for the day, and we can take this up at 8:30 in the morning and have the jury be back at 9, and we can start that. If you don't mind, are you available to come back tomorrow? Okay, thank you very much. So Ms. Rumpf is available to come back tomorrow. The court will bring the jury back in. We'll recess for overnight and give counsel an opportunity to do the research on this overnight, as will the court, and have counsel back at 8:30 to continue this argument. And as I said, we'll have the jury come back at 9. Is that acceptable to both sides?
Yes, Your Honor, and I'm sorry, I missed the time for counsel to report. What time?
8:30?
8:30, yes, Your Honor.
Acceptable?
Yes, sir.
Okay, let's go ahead and bring the jury back in so I can discharge them for the day.
Jurors are present, Your Honor.
Please be seated. Don't get too comfortable. The matter that we're taking up outside your presence is going to take a little longer, and instead of having you sitting back there, I'm going to recess as far as the jury is concerned for the day. So we will see you at 9 a.m. Tomorrow morning. If you'll please give me a moment, I'll go ahead and give you my instructions during the overnight recess. You're not to discuss the case amongst yourselves or with anybody else. You're not to read or listen to any radio, television, or newspaper reports about the case. You're not to use any electronic device to do independent research about the case, people, places, things, or terminology. And you're not to read or create any emails, text messages, Twitters, tweets, blogs, text messages, or social networking pages about the case. Does everybody agree to abide by the court's instructions? Okay, is there anybody who is not going to be able to abide by that? Okay, I'm not hearing anything. With that, you're excused for the evening. Enjoy your evening. Please leave your notepads face down. They will be locked up overnight. Please be seated. Ms. Rupp, you're excused until tomorrow morning at 9 a.m. During the overnight recess, you are still under oath. It's as if you're still on the stand, so you're not to discuss your testimony with anybody. That includes the lawyers. Okay, thank you very much. You're excused until 9. Counsel, is there anything else we need to take up before we recess for the evening?
No.
We'll see counsel at 8:30 in the morning. Court is in recess. Have them individually marked.
Yes, ma'am.
So those exhibits that are individually marked need to be given to the clerk. And so do you have exhibits 1 through 163 here with you now?
I can put them on a disc in very short order
Okay.
and tender it to the clerk.
Marked.
Yes, ma'am.
The clerk's supposed to take possession
Yes.
of any exhibits that are marked.
Yes, ma'am. I will provide a CD before we leave.
The CD is going to be marked as one exhibit. You have them marked 1 through 163. If you have a clerk sticker on them and they've already been accepted, they have to be in the clerk's possession. Do you have them with you?
Not in the hard copies, but I can make a
then,
CD. I'm sorry, I'm not understanding what you're saying.
No, I understand what you're saying, but you've handed me an exhibit list, and you have exhibits, each one individually marked,
Yes,
1
ma'am.
through 163.
Yes, ma'am.
Those have been accepted into evidence. 163 pieces of paper need to be given to the clerk because that's how they're marked.
Yes, ma'am.
Okay, you don't have them with you now?
I don't, but I will get them, within 30 minutes.
The court will make an exception and have them here in the morning. Okay, thank you very much. Anything else? Susan, are you okay? Okay, thank you. Court will be in recess.